I want to bring in now Timothy Parlatore. He served as a Trump attorney but left due to differences with Trump advisor Boris Epshteyn. Mr. Parlatore joins us now, and good to see you. Thank you so much for joining us. So have you spoken with any of the former president's attorneys about their strategy to defend him? What's next?
I have not spoken with any of the current team about this. You know, my tenure on the legal team ended in about a month ago, and certainly I remain close with John Rowley and Jim Trusty, but I'm not in contact with the current team.
Tim, do you know, how many different attorneys has Donald Trump had recently, and how many of them resigned and why?
Well, look, he has a lot of different attorneys because he has a lot of different cases. And, I can't really speak for anybody else. I have my reasons, which I did discuss at the time that I left. It's not something I really want to, belabor. It's difficult to represent a client in a case like this when there are other influences at play. So that's why I felt that it was best for me to leave. And certainly I hope that he will find a team that can properly defend him in this case.
No doubt you have read through all 49 pages of this indictment and looked closely at some of the evidence in this indictment. The former Attorney General, Bill Barr, calls this a very, very damning indictment. Is he wrong?
Well, I think that the problem is you look at the indictment, and if you just read it by itself and you assume that everything in it is true, and you kind of ignore a lot of the conduct of the DOJ team in getting to this point, it can look that way. However, as a criminal defense attorney, one of the things that I do for a living is I take documents like this, I look at them a little bit more skeptically, I then go through the evidence to see if it actually matches up. And oftentimes it doesn't. DOJ oftentimes will bring indictments where by the time we get to discovery, we realize these aren't true. Or they're certainly not as airtight. Maybe there are 30 witnesses that say something one way, a couple that say something the other way, and they'll just write what some of the witnesses said instead of the rest.
Okay, well,
so
Tim, what specifically?
Just because it looks damning.
Specifically?
The thing that jumped out to me specifically is kind of the big hurdle that they're going to have to overcome is the exchange between Trump and Walt Nauta before Evan did his search, which they claim is based on all these video surveillance and phone records. And if that's true, then that's a pretty big hurdle. But at the same time, if that's true, then it's something that they would have used before now to try and convince Walt Nauta to change his story. And so the manner in which the investigation was conducted surrounding that undermines the credibility of that.
All right, I understand your point, but I'm not sure that the body man or the personal aide or the valet is central to this case. I think some of the most damning evidence comes from Trump's former attorney, Evan Corcoran. And so on that note, I wonder, because as you know, the crime fraud exception was used, granted by a federal judge, to pierce the attorney-client privilege, which then allowed the notes and voice memos to be administered, in which, if you believe what is in the indictment, it's more evidence that Donald Trump continued to try and obstruct a federal investigation in an effort to return these presidential records. Do you believe that Trump's new attorneys will try and dismiss the testimony of Evan Corcoran?
I think that the testimony of Evan Corcoran is something that will be suppressed because I believe, Judge Howell's decision on the crime fraud exception there was wrong. And I think it is something that Judge Cannon will have to reevaluate. Unfortunately, when you're litigating these issues in the context of grand jury proceedings, because of secrecy laws, it's not the same as when you ordinarily litigate a motion. The government puts forth their case, which the defense is not allowed to see. We then have to respond to arguments that we're not allowed to read or know what they have argued. And ultimately, the judge makes that decision based on really only hearing intelligent, coherent arguments from one side because the other side is totally in the dark. Now that we've actually gone through this and seen all the notes, it's clear to me that these are proper attorney-client communications, not something that should ever have been disclosed. And if you look at those specific discussions, what he's asking
even if it was
there
in furtherance of a crime?
What?
Tim.
But it's not.
Tim, I want to ask you on
just
that
because you charge
I understand that. I agree. Everybody believes.
No.
I know this is a very, very rare exception. This is almost never pierced. Attorney-client privilege is never pierced.
Correct.
But my understanding is that Judge Howell, who allowed the crime fraud exception, said that the government made a prima facie showing that Trump committed a criminal offense and that the evidence was a transcript of audio notes that Corcoran made. I mean, this is so rare. And Trump lost this before a grand jury. So, again, give me your best argument about why you think this will be suppressed.
Because Judge Howell, in my opinion, got it wrong. She didn't hear from the other side. We weren't able to fully litigate the motion. And now that you see what's in the notes, it's clear that she got it wrong because these are attorney-client privilege communications. He's asking about what are we required to do? What are we allowed to do? And one thing that's kind of lost in what's in the indictment is the context here where he's specifically saying, look, I read about when Hillary Clinton got a subpoena and David Kendall deleted 33,000 emails. Are we allowed to do the same thing because they didn't get into trouble? You want clients to ask you those kinds of questions. You want to encourage them to ask those kind of questions so that they understand what their rights are, what their responsibilities are, but you want them to discuss that in an attorney-client privileged environment. And I think that the precedent that Jack Smith is trying to set here is extraordinarily dangerous because what he's trying to set here is if you ask a question to your attorney that the answer is no, then the government is going to try and pierce attorney-client privilege and then charge you for asking a question. It's very dangerous. It's very unconstitutional. It's not something that he should be doing or that anybody in DOJ should be doing. And any attorney who has actually counseled clients who have received grand jury subpoenas will look at this with the full context and know there's nothing criminal about that exchange. And so therefore, it should never have been disclosed. You know, there is potentially a crime fraud exception argument for Evans saying when he was going to do the search. Just that piece of it so that that could be in furtherance of when Walt Nauta moved the boxes. That doesn't mean you give over all of these other pages of notes and all of these other attorney-client privilege communications. And I think that that did irreparably taint the grand jury proceedings. And moreover, Judge Howell, when she rendered that decision, she didn't give us the opportunity to appeal. Ordinarily, you have a couple of days to appeal before they hand over the notes, and you go to the circuit and you try and stay it. She didn't wait. She immediately gave the notes over to the prosecutors, thereby mooting the appeal so that we wouldn't be allowed to go up. So that's something that I think that the trial judge is going to take a hard look at, and really I would expect that this would get reversed and go back and say, no, this was not properly disclosed.
Tim Parlatore, former attorney for Donald Trump. Thank you, Tim, for joining us.